poverty. And also we have some insight extracted over 3 cases. Then, what is the fact pattern presented in Morgan versus United States? In Morgan, we have a complex set of facts that lead up to a legal dispute where the regulated parties, in this case, the stockyard operators, were treated fairly by government administrators. In 1921, Congress authorized the Secretary of Agriculture to specify maximum just and reasonable charges the stockyard operators could set for their services. In Packers and Stockyards Act of 1921, Congress instructed the Secretary to do so only after a full hearing. In 1930, the department notified Morgan and other stockyard operators to appear for hearing concerning their prices. The hearing, which had to be held twice due to the rapidly changing conditions in depression, took many months and accumulated a 10,000-page transcript of oral testimony and another 1,000 pages of statistical excerpts. Initially, the Secretary of Agriculture did not personally review the hearing at all. So, you will learn the American Administrative Procedure Act, in abbreviation termed as APA, and the statute would include the principles and scope of requirements that the state administrations agencies have to respect. And what is the concept in this progress? You will see some public forum to make a more effective decision in consonance and agreement between the agencies and involved parties. So, massive evidential product and oral exchange of ideas and opinions. So, consulting between parties. So, the concept is on a participation. So, as I've said, the administrative agencies have to act with respect to information, participation, and accountability. So they would highly do better to undertake this kind of a process as required. Then, on the basis of this process, the administrative agencies need to make a more informed decision, and also have to allow some possible opinions in appeal or for correction. So they have to take a process measure to reach a complete resolution about the case. That could lack, as you read in next page. So let us get further. In an earlier case, the Secretary of Agriculture delegated to subordinates the job of listening to the oral arguments based on the hearing. In an earlier case involving Moreland, the stockyard operators appealed to the Supreme Court, claiming that they did not have a full or fair hearing because the decider had not reviewed the evidence. The court agreed and sent the case back to the Department of Agriculture to try again. So the Department of Agriculture now undertakes some kind of a adjudication, and that is one concept also prescribed in APA. So the modern administrative agencies have a sort of a adjudicating role, as you see in the independent tribunal, and a kind of a classified decisions about important private and public issues. Before the completion of the next round, a new secretary was appointed. He did receive and review a list of 180 hearing findings organized by the Department Bureau of Animal Industries. The secretary made a few minor changes in the findings, but otherwise approved them and ordered the stockyards to lower their prices. This time, when the court heard the case, the stockyard operators had a new set of complaints. And typically, you will see in this case the neglect of a department or other concerned public agencies to give a standard and reasons adequate to understand their decision. That could not be rendered in any concrete manner. So actually the interested parties get at art unfairly. The expression in this case would be interesting, you see. The Bureau of Animal Industries has been in effect the prosecutor in the case. For the secretary to rely only on his assessment of the issues seemed unfair to the stockyard operators. So now we get at this. The operators were not allowed to see the tentative report of the examining hearing, so they had no basis for defining and making their final arguments, nor were they allowed to see the Bureau's findings. So actually, due process of law concept required to give a scope of reasons pertinent to their findings or disposition. That also could be based on the institution, which is important about judicial review and analysis. So they may appeal and may file a complaint. That could be a precious opportunity the drafters of a due process of law concept could expect. So, interesting expression we now face with. The department in effect left them punching the air. Indeed, from the very beginning of the case, the department never formulated a specific complaint against the prices the stockyards charge. The opinion of court follows properly insists. The opinion of court follows properly insists on basic administrative fairness. So it is important concept, administrative fairness. A kind of vantage point, the due process of law concept should be directed. Morgan was one of the court's first serious efforts to define administrative fairness in a modern administrative setting. So you also have a nuance of equal footing, equal standing between the public agencies and people, interest party, who would be a private person or firms or enterprises. Often we structure the public administration or rule of government as one of exercise of sovereign power. So they will rule. So they overhaul the policy addresses, and there is one concept we consider. However, that should be moderated. by affording a proper process, adequate process to deal with the question or issues. So it would yield the public good to situate both parties in contention on equal footing, public agencies and private parties. That is concept we now cherish in democratic rule, participation and accountability. And also substantive standards should be issued, not to derogate any embedded values. In fact, this case had to go back twice more to court before the dust finally settled. As you read this first example of admissible law in action, try to imagine some additional potential defects in a hearing to make it unfair. So, in the court opinion, we'll find some paragraph which is useful to grasp the law. Congress, in requiring a full hearing, have regard to judicial standard, not in any technical sense, but with respect to those fundamental requirements of fairness, which are of the essence of due process in a proceeding of a judicial nature. So the process required could vary in extent of a severity or a fault. So in some cases, a strict mechanism would be bold to suffice the due process of law requirement, so kind of judicial nature. So adversary proceeding, and many states to be contended and debated by engaged parties. Full opportunity to be heard of interest. In other cases, the process could be concise and afforded in summary form, so basic exposition of facts and pertinent rules, and allow an opportunity to complain about the deprivation of any vested rights or entitlement. Consider the example of dismissal of university professors, state university professors, for example. And in other case, you will encounter loss of license, private license. What else? And in some cases, business license may be revoked on any public reason. For example, failure of juvenile man, juvenile class, or sales of midnight. Sales of liquor in midnight to procure the kind of risky circumstances about traffic accident. So there are a class of circumstances and situations involved, and the seriousness of a admissive sanction, others. So compare those factors in response with the adequate provision of a due process. The answer that the proceeding before the Secretary was not of an adversary character, as it was not upon complaint, but was initiated as a general inquiry, is futile. So the scope of an argument could be dealt in court opinion. So read carefully through the court opinion and obtain educatory in understanding the due process of law. And in Goldberg, you will consider other contexts involving social welfare benefit. Several residents of New York City, Kelly among them, receive welfare payments from the federally assisted aid to families with a Department Children Program or the state's home relief program. They brochured to prevent the termination of the welfare payments before a hearing has taken place. New York law did, however, allow oral hearing before an independent state hearing officer at termination, at which time the recipient could offer oral evidence, cross-examine witnesses, and have a record made of the hearing. If the recipient wins at this hearing, he or she receives all the funds erroneously recorded. So the New York state law actually afforded some mechanism and process to respond with their administrative action. In some cases, they need to recognize the status to be eligible for social welfare benefit. Many public programs, typically involving child care or subsidies for sound families, often frequent and fill public needs, and many available in the United States society. So, what do you think any desired form of process in this case? Your focus needs to be given that the review a priori would not be afforded in this case. The process could be initiated after termination of welfare benefit. That is one factor whether it would advocate or unconstitutional. So that would be next topic, that in the next class. Okay, that will be all for this class. Any question? Okay, thank you for your attention. See you in the next class. 네, 김동희,
네.
박은비,
네.
김현창, 네. 김재현,
네.
한 분 이상.
이윤경이요.
이윤경.